turn the page, just flip, flap, and click. The book page holder is not sold in stores, but available only through this limited-time exclusive TV offer for just $5.95. Here's how to order. Call 682-8496, 682-8496, or send your check or money order for $5.95 to Book Page Holder, 726 Richard Street, Vancouver, V6B3L2. Be sure to include your name, address, and postal code. This is a limited-time offer, so order now. That number again, 682-8496, 682-8496.
BCTV, our best showing.
Good morning. New laws affecting the serious crime of rape are now in effect in Canada. Some members of the legal profession think that these amendments by the Liberal government are a knee-jerk response to a very loud group of feminists. Other members of the profession think that it has downgraded the serious offence of rape in some particular instances. So, to get it right this morning, I have with me one of British Columbia's top criminal lawyers, Josiah Wood, who will spell out precisely what the new laws of rape mean to the public of Canada. Now, also this morning, and I have no particular problems myself, I have Michael Livingston, a doctor who's the expert, I'm told, on how to look after your poor, sore, sacroiliac, etc., your back. But he has with him an expert by the name of Ezekiel. There's Ezekiel, wearing a straw hat, although it's not a funny subject. And now you're going to see Ezekiel in action on a WCB commercial
Have a little pain in the back, eh? Well, stop and think. Perhaps it's trying to tell you something. You try to lift too much, or bend your back when you lift, or twist with a heavy load. Maybe it's had enough of all that abuse. Maybe it's time you started strengthening your relationship with proper exercise. And along with that exercise, start using your back the right way.
And in fact, we're going to use the real-life skeleton of Michael Livingston to give us a demonstration or two. Now, on a serious topic towards the end of the program, it's a fact that when cultures collide, the first victims are the children of the minority. And Patrick Johnston has written a book on Native children, Indian children, and the child welfare system. And there's a lot specifically referring to British Columbia, but that's for later. First, Josiah Wood and the effect and meaning of the new rape laws for Canada after the break. Josiah Wood is a bencher of the Law Society and one of BC's top criminal lawyers. First question, Mr. Wood, are these new rape laws in effect now?
No, well, they are in effect now, but the effect of them will not be felt for some time. The transition date was the 4th of January. Any charges laid after that date are dealt with as though under the new provisions. Any charges that arose before that date are dealt with as though those provisions had never come into existence.
Will they make any appreciable difference to the handling of offenders with what was called rape in front of the courts?
There will be some changes, certainly. There will be changes of an evidentiary nature. There are many changes in that respect in the new sections. Essentially, 90% of your rape cases, 95% of the rape cases that come before the courts, the issue is consent. That issue is still there. The issue of consent is still going to be the major issue in what is now called a sexual assault rather than a rape.
So there's no more rape as such?
Rape has disappeared as a defined offense, that's right.
How many different categories of this new sexual... Well, first of all, was rape not once a capital punishment offense?
It was.
How long ago was that?
Oh, just before the turn of the century, as I recall, that the law was changed to make it one that was punishable by life imprisonment.
And under the old criminal code was the maximum for all forms of rape what?
Life imprisonment.
And now we've got different categories.
That's right.
Does this in effect downgrade the seriousness of a rape or the new forms of sexual assault as such?
I believe it does, because the majority of what is called rape will fit into the first category, the lowest category of sexual assault. Now, there are 3 levels of sexual assault, 3 categories. And that is punishable now by a maximum of 10 years imprisonment.
Is it possible to ask you, what kind of sexual assault is that?
Well, the term isn't defined in the new sections, but it will be anything, including an act of rape, what used to be rape, where there is either no bodily harm to the complainant or no threats of bodily harm to other persons or use of a weapon.
That would call for 10 years maximum.
That's right.
On any of these, is physical penetration now a part of the evidence of any of these new 3 categories of sexual assault?
It's not a required ingredient of the offense, no. The concept of assault does not necessarily include the act of intercourse or penetration. Needless to say, if that is what has occurred, then that is still going to be an issue in the trial.
But you can be convicted of sexual assault, and attempted rape would become sexual assault.
Attempted rape has disappeared as an offense as well, that's right.
Altogether it's?
Yes.
And an attempted rape sounds much more serious than a sexual assault carrying 10 years where there's been no bodily harm or threats.
Well, it was a far more serious offense. It was one that was punishable by a maximum of 14 years imprisonment.
What is the second, more serious category now for sexual assault?
The second category is one where the sexual assault is accompanied by the use or the threat to use a weapon, where, and there are 4 categories that create this second level of sexual assault, where the perpetrator threatens to cause bodily harm, and this is interesting, to a person other than the complainant. Now, I will just pause on that, because if the perpetrator threatens to cause the complainant bodily harm, that's a less serious offense than if the perpetrator threatens to cause bodily harm to a third person.
In other words, if you break in by night and you get hold of a woman and you say, unless you consent, I'll kill your child sleeping over there.
That is an aggravated form, or not aggravated, but it is the second level of sexual assault. But if you break into that same apartment and say, unless you have intercourse with me, I will kill you, without having a weapon on your person, that's a less serious offense.
That's odd.
It is odd. I don't understand the rationale behind it, but that's the effect of the new sections.
And the most serious of sexual assault is what?
The most serious is that where the complainant is either wounded, maimed, or disfigured, or her life, or his or her life, is endangered. Now, one of the things to note is that these offenses have been neutered. They can be committed by either a man or a woman against either a man or a woman. There is no, the sexual or the sex of the perpetrator and the sex of the victim are irrelevant to the crimes as defined.
Does that make sense to you?
It doesn't really have a great deal to do with it. I mean, in actual fact, most sexual assaults are perpetrated by men against women. And I don't think that's going to change. I don't think that the pattern of conduct of men and women is going to change as a result of these offenses.
So if you're wounded or maimed in an attack of any kind, well, it's got to be a sexual attack, hasn't it?
Yes, if you're wounded, or if there's a sexual assault that takes place, and there is a wounding, a maiming, or an endangering of the life of the complainant, then that is what is called aggravated sexual assault, and that's punishable by life imprisonment.
Life imprisonment.
That would cover perhaps 5% of what are the rapes that are normally reported.
I don't suppose it's possible to give me an opinion on compared to the old. It would seem to me that you had a much worse chance as an accused rapist of getting life imprisonment under the old, fairly straightforward rape laws than you do now.
A worse chance or a greater chance?
A greater chance under the old law.
Yeah, I think that the indication that Parliament has given to the courts is that the most common form of rape is now a far less serious offense. What the courts will do with that, whether that will in fact demonstrate itself in a trend of lower sentences for your average, what some people call garden variety rape, whatever that may mean, but your standard rape remains to be seen.
Are you concerned, however, about the change in the rules of evidence? Because I read a report of you at a panel where I thought, hey, that's a bit odd. One of them being the fact that about the timing of the complaint of rape. Now, what is that complication?
Well, the laws with respect to recent complaint have been abrogated under these new sections. Now, what that means is this, that under the old law, a complainant in a sexual offense, if that person, and it was generally speaking a female, complained at the first possible opportunity to a third person, and that complaint was given without being extracted by cross-examination or leading questions, and it related to the actual assault. That, even though it was technically hearsay evidence and inadmissible, was admissible in a subsequent trial as an exception to the hearsay rule. It was called the recent complaint. The recent complaint obviously was a very important corroborating factor in terms of the proof of the offense. Now, those laws have been abrogated, whatever that means.
Wiped out, I presume.
Essentially, the exception to the hearsay rule has obviously been wiped out. In other words, the evidence itself of what was said is now not presumably going to be admissible. However, the fact that something was said or wasn't said, it seems to me, is still admissible. The fact of whether or not the complainant spoke to somebody immediately thereafter.
Oh, I thought that this abrogation of this thing meant if a woman is raped or believes she has been raped, knows she's been raped, can she now sit back for 6 months before she lays the complaint?
Well, she always could. The issue as to whether or not she was raped no longer is affected by the fact that she may have made a complaint only 6 months or 2 years or whatever after the
You couldn't make a complaint 2 years after, 6 months after, could
Those
you?
circumstances have arisen.
They have
Particularly
arisen.
with young complainants who find it difficult to complain even to their parents about what has happened.
That's a good thing?
In some senses, it's a good thing, yes, because too much emphasis, I think, was placed upon the recent complaint. You see, the laws with respect to recent complaint did not take into account the personal psychological factors that are present when you have young complainants, when you have complainants who are under tremendous pressure from families or others.
But doesn't that wipe out an element of corroboration which makes it more difficult to convict the rapist?
But corroboration has disappeared completely from the law as well.
What do you mean?
Well, it's no longer necessary to have corroboration for any form of sexual offense in order to obtain a conviction. It is no longer necessary for a judge to warn a jury that it is dangerous to convict on the uncorroborated evidence of a complainant.
Is that good?
Again, I think that the emphasis was, you see, the essence that lay behind the rules relating to corroboration was that there was some reason to distrust this complaint. Unless it could be independently verified, you should look with suspicious eyes upon any complaint by a woman about sexual misconduct on the part of a man.
And that, of course, I presume, was what the feminists objected to very
I would think
loudly,
so.
and perhaps properly.
To some extent, yes, because there undoubtedly were instances where too much emphasis was placed on corroboration. But it doesn't, you know, the fact that the law with respect to corroboration has been effectively eliminated does not do anything with respect to what seems to me to be a fairly common sense proposition, and that is that if there is a complaint which seems suspicious and there's nothing else to verify it, juries in particular, who have usually an abundance of common sense, are probably not going to give effect to the complaint.
More with Joe Woods on the precise meaning of the new rape laws now in effect in Canada after the break. Let's see if I've learned my lesson correctly. From Josiah Wood. Aggravated sexual assault, weapons, wounding, maiming, life imprisonment, right? Sexual assault, threats with weapons and bodily harm, 14 years. Garden variety rape, to use your phrase, not my phrase, I disassociate myself from that phrase.
It's not mine either, but it's one that you hear commonly.
No threats, no weapons, 10 years.
That's right.
But you were coming to the very tricky bit of evidence, and I don't know how to interpret it, maybe you can. You say the time factor about recent complaints is wiped out for the
Well,
moment.
the recent complaints themselves are no longer admissible.
What about no corroboration required
That's right.
for a sexual assault
That's
case?
right. That's right.
None. There will still be juries, I trust,
Yes.
if the accused so wishes,
Oh, yes.
right? Now, what about the other one? What about the previous sexual conduct of the woman, which was the thing raised in loud voices by the feminist groups?
Well, in 1976, the law was changed to provide that if you were going to cross-examine a complainant about prior sexual conduct, you had to give notice of the questions you were going to ask, and the judge made a determination on the basis of that notice, usually in a hearing with the jury absent, as to whether those questions were relevant to the issues that were before the court, whether they had some weight, some probative value. The law has been changed quite significantly in that respect. First of all, what is referred to in these new sections as the sexual reputation of the complainant is a matter which is not to be referred to at all. It is, you are prohibited from raising the sexual reputation of the complainant.
Regardless?
That's right.
That's a ban.
Yes. The second change is that under these new sections, the only questions that you can ask about the prior sexual conduct of the complainant are limited to 3 narrow categories. And again, with respect to at least one of those, you must give written notice and undergo the process that we had before, whereby the judge screened them and determined whether there was substantial weight to be attributed to them. Now, those, I don't know if you want to get into the 3 narrow categories, but they are essentially, the first one is where the Crown, and would have to be a case of the Crown mistakenly leading evidence from the complainant whereby she suggested that she was of pure or he or she was of pure sexual background.
Like saying you had no criminal record.
Yeah. Said something that you had evidence or proof of was incorrect. You could then lead evidence to show that that was a false statement. That's number 1. Number 2 is where you, in effect, if you are an accused person, are raising the defense that it wasn't me, it was him.
Right.
Then you are allowed, of course, to put that proposition to the complainant.
Right.
The third very narrow category is where, and it appears that it can only arise in what is sometimes referred to as the gang rape situation, where you are in fact raising a defense that sexual intercourse took place between the complainant or sexual contact took place between the complainant and some other person at about the same time. Now that would be done presumably in the context of what is called the mistaken belief that the complainant in your case was consenting. Now that is another change, a significant change in the statutory law, that there is now a statutory defense of mistaken belief in consent.
So that's good, I suppose, in a woman, regardless of her previous reputation, even if she were a hooker who hadn't been paid, can complain sexual assault.
Yes. But, you know, those were very rare instances, the gang rape or the orgy situation where the defense of mistaken consent might reasonably be said to arise. They're very rare. I mean, maybe only that they're very rarely reported, but they're very rarely before the courts.
Is medical examination, if a woman were raped with this new law in effect, what is the wise thing for her to do in terms of proof? See the doctor, go to the hospital? Is that the same drill as was before? Because even though you don't have to prove penetration, presumably medical evidence could say, yes, this woman was attacked.
The medical evidence, insofar as it went to show that there had been sexual conduct, would be relevant and admissible. It would be one of those things that would be confirmatory of the complainant's testimony. Not necessary just in terms of corroboration, but confirmatory.
It would seem to me to make it, in some cases, more difficult to have a conviction.
For what?
For any of these categories of rape.
I don't know that it's going to be more difficult to get a conviction. I think that the rationale behind them was that it would be easier to get a conviction if the penalties were less severe. Juries would be less reluctant to convict. That's a peculiar theory of criminal justice, but that was, I think, one of the rationales behind these changes. Now,
it means the jury now has an option, instead of bringing in convicted of aggravated sexual assault, of going down a step, does it?
I don't think it's going to make a big difference because, for example, eliminating the notion of intercourse or penetration, which was the essence of rape from the criminal law, essentially, there were not a lot of rape cases where the actual act of intercourse was the issue. Consent was the issue, and as I said before, in 90% of the rape cases that came before the courts. That remains as an issue.
Reminds me of one case, and I don't know if this is from an old case or the new law. If a man thinks that although a woman said no, she was in fact consenting, is that a defense against sexual assault of any category?
Well, I referred to that a moment ago, and that's what is referred to as the mistaken belief in consent. An honest but mistaken belief that the complainant is consenting.
Woman says no, the guy thinks she means yes, carries on. That's a mistaken belief.
Well, if it's an honestly held mistaken belief. Now, you can appreciate that, you know, thinking about it reasonably, there would be few circumstances in which such a situation could arise. And indeed, you know, it's only in the last 25 or 30 years that the law has even talked about this as a potential defense to a charge of rape. And it stems from some House of Lords case in England and some cases in Australia. You wonder why, after hundreds of years where the crime of rape has been on the statute books, it's only in the last 25 or 30 years that all of a sudden the courts have started to concern themselves with a defense of an honest but mistaken belief, something very rarely given effect to.
Overall, are the changes worth the while?
Well, it remains to be seen, I suppose. I'm not sure that they amount to an awful lot. Those sections which I suppose were intended to remove the gender, if you will, of the offender and the person complaining, because of some notion that they should have equal application. I don't know whether that's a significant change or not. All of the seduction offenses remain with the same sexual character that they had before. In other words, they are offenses committed by men against women.
So the legal jury is still out, you being the legal jury on this occasion, as to the efficaciousness or the effectiveness. But it would allow more room for plea bargaining, wouldn't it? Do we plea bargain, Mr. Wood?
In fact,
in our system?
Sure, that is a necessary component of any reasonable justice system. It goes on. If reasonable people are going to be dealing on opposite sides of the same case, they're going to talk about it. They're going to talk about what the proper disposition of that case should be. And if they are reasonable people, frequently they will arrive at a proper disposition without the necessity of there being a trial.
Before I go to telephone calls, which I'm going to take now, I want to nag you a little bit about my cynicism about what appears to be a great crisis in legal aid, which is involved in this, obviously, after the break. Josiah Wood, what are the major concessions to women in this new sexual assault law?
Well, the one is the evidentiary matter that we spoke about, which restricts very severely the right to cross-examine complainants about prior sexual conduct, because most complainants are women, and I think that situation will continue. The second
is that
thing,
good?
I think by and large the change is going to affect the possibility of a fair trial in some instances, I'm sure.
In other words, it's sexist and against men as such.
It may be, but I think that there were definitely abuses in that area in the past that were not significantly addressed in the 1976 amendments. And so what change has occurred is probably overall for the better.
Secondly,
the curious thing is that now you can be raped by your spouse, or you can be sexually assaulted by your spouse. And that's a significant change in the law, because of course the old offense of rape was one committed by a man, and it was with a woman who was not his wife. That was an essential ingredient of the offense. Now it is possible for a spouse to complain about the sexual assault made upon him or her by the other spouse.
You mean after separation or divorce or what? Or while they're legally married and living together?
Yeah.
Is that bad or good? How many of these have...
That, I think, probably is a good change from the point of view of, again, women, because women, by and large, will be the major complainers, and there are certainly, we know, those who have practiced in the field of family law at all, and I don't do a lot of that, but I know lawyers, I've talked with many lawyers who do.
One of the officials of legal aid said yesterday, he's changing the subject quickly, that there may be cases of rape and murder coming up in a 3-month period this summer where lawyers will not be supplied. I can't accept that.
Well, Jack, it's a very real possibility as I see the cutbacks that the society has been compelled to introduce. There will be no tariff cases at all for the 3-month period. That is to say, any charges arising between the 15th of May and the 15th of August. There will be no tariff assignment of legal aid.
No legal aid lawyers will be put on the cases?
Well, the only legal aid available will be staff counsel. And if there are areas where there are no staff counsel, or staff counsel you can imagine are going to be overburdened to begin with, there is the real possibility that there will be people appearing before the court on serious offenses without counsel.
$17 million a year in the next amount, and now they want another 2.75. Has it been well run, or has legal aid become welfare for lawyers?
Well, Jack, the evidence that we have, and I'm on a committee that the Law Society has struck with respect to this whole legal aid crisis, the evidence that we have, And I think it's good evidence, it's evidence you can rely on, suggests to us that our legal aid system is one of the best run, most efficiently run systems in the country.
What are you saying to the Attorney General then, in effect? You must give us the money or people will be denied justice.
As I understand it, the problem is not with the Attorney General, who has been in favor of supporting the legal aid system and granting or seeing to the disbursement of greater funds to the society. The problem appears to be with something called Treasury Board, whoever that or whatever that may be.
Let me put on my other hat. I never was in favor of the Charter of Rights. I think it's a bonanza for the legal profession. But my other hat is that I am entitled under the Charter of Rights to fundamental justice and a fair trial. And if I'm Webster defending himself against a prosecutor of your caliber, I'm dead in the water.
Well,
I must have a lawyer. Does the Charter of Rights passed by the federal government supply money for lawyers?
No, the Charter itself doesn't. Now, there is, of course, a provision in the criminal code that permits the, and certainly the judges in our courts have always exercised this jurisdiction, permits a judge to order that counsel be provided for somebody who is appearing before them without counsel.
That was in the old days on a murder charge. The Attorney General would appoint a lawyer, or I've seen Oscar Orr say.
It has happened, yes, it has happened. It's happened to me. I've been appointed in those circumstances to act for somebody who has not had counsel. And then when that happens, the Attorney General is required to pay. That's got nothing to do with the Legal Aid Society or the Legal Services Society. But that provision is there. But I mean, you can understand that if that happens on a wide scale, that the cost to the government is going to be far greater than if in fact they had funded the Legal Services Society properly.
Let me
make this other comment if I've got time.
Please, go
because the other thing the other fact or facts that come to light when we look at this situation is that we're in the middle of a depression, and that's why. You know, the people's contact with the law increases in those difficult economic times. Stress causes more marital breakups. Stress and desperation causes people to turn to avenues which bring them in contact with the law. That's not peculiar to British Columbia. It's a phenomenon experienced across the country. Every legal aid system across the country is overdrawn on its budget this year, is facing a deficit. In every province, that deficit has been met by the government. Every legal aid system across the country has had to budget for a far increased or greater budget next year because of these unusual economic circumstances. Every province across the country, the government is meeting that new budget.
Except?
This is the only province in the country where, in fact, the government apparently is refusing to increase the legal aid budget for next year beyond what it was this year.
Well, it now becomes a real crisis then. If you're going to cut off all legal aid lawyers for a 3-month period, presumably so you can swallow the deficit, that means people who ask for legal aid, and you don't get it in all circumstances now anyway, do you?
Oh, you don't. I mean, the system is restrictive to begin with. It is now, I mean, for that 3-month period of time, there will virtually be no legal aid at all, except, and don't forget this as well, that they are, in addition to there being no tariff for those 3 months, they're cutting back by 13 the number of staff lawyers in the province. Now, I believe it's something over 40 staff lawyers, and there are a number of other small storefront operations which are funded by the society. They're independent, but they're funded to some extent. And but that is a fairly significant reduction in the full-time permanent staff that are available to handle these legal aid cases.
And is the Law Society going to fight this directly with the Treasury Board or just lobby through Williams?
Well, the Law Society committee is meeting tomorrow at lunchtime to discuss this new emergency situation that has arisen. The committee was actually struck before this arose. The purpose of that committee is twofold. It's to, in effect, seek to persuade government to give a proper priority to the costs of legal aid in this province, both on a short-term and a long-term basis. The second thing is to exhort our own members in these difficult times to engage in more pro bono work, as much pro bono work as we can individually afford to do, because we are facing a crisis situation.
Pro bono work?
Yeah.
What do you mean, pro bono?
Free work.
You mean pro bono publico?
Free legal work, Jack.
You mean the good old charity legal system that was in effect in the 40s?
Well, and beyond that, and is still in effect today.
Yeah, I'm not knocking you for it.
Yeah.
But isn't it ironic that we've got all this fancy new Charter of Rights, full, fair, fundamental justice and all the rest of it, and when it comes down to nitty-gritty, it doesn't mean a damn thing unless the provincial government puts up the money.
Or the lawyers themselves, on their own responsibility, do the work.
Time for one segment of calls with Josiah Wood after this break. Josiah Wood on the new rape laws. Can't call them rape laws anymore.
No.
Aggravated sexual assault laws.
Sexual assault laws, yes.
Go ahead, please.
Yes, I would like Mr. Wood to comment on the following. I feel that with the advent of these changes, that in some ways the complainant still appears to be the accused. Number one, with the defense of honest belief, if a man raped or, say, aggravated assault against his wife, could he use the honest belief defense and say, well, it's because of past sexual intercourse in married life, he felt his wife, or it was his honest belief that his wife desired that. Number two, I wondered if a complainant's past sexual history is automatically required to be given as evidence in court under the new laws. And number three, Mr. Wood's comment on the Alberta court judges saying that if a woman accompanies a man home or for a drink or for anything else, that she can expect to be raped.
At 4 o'clock in the morning after a few beers it was.
That's right.
3
That's
points.
it. Thank you.
Thank you. 3 points.
Well, maybe I can deal with the third one last, or first rather, and that is I don't think that that particular statement requires any comment. It speaks for itself. And as a member of the bar in Alberta as well as British Columbia, I wouldn't want to go any further than that. I just don't think that's a relevant concept at all in British Columbia, and I wouldn't worry about that in this province. Now, and I don't think it'll last either as a notion or a concept in Alberta. Now, the second thing is that you ask about whether the complainant's sexual background is automatically to be revealed, and no, that's one of the points of these new provisions, is that evidence of sexual reputation is not admissible, and indeed there are only certain very narrow, limited grounds upon which you can cross-examine the complainant about prior sexual conduct at all.
Wife?
The question of the wife, yeah, and an honest belief. It's a very interesting question, and it's one that will take some time to evolve in the law. I really can't answer that question at this point in time. It's going to be one of the more difficult applications of an honest but mistaken belief defense.
Go ahead, please.
Hello?
That's you, sir.
Okay, Joe. I would like to make an example of statement of what happened to me one time when I was quite young, and then ask a question.
Keep it short.
The new laws are making it easier for women to charge rape. I was going down Kingsway one day, and I picked up this hitchhiker. She wanted a ride. I got about 2 or 3 blocks down the street, and she said, I'm going to tear all my clothes off and scream rape if you don't give me $20, I think she wanted. And I, at the time, was young and knew what to do. I just locked my doors off. Luckily, I had one of the kind of cars you can lock your doors from the driver's seat, drove her right down to the front of the police station, and said, now go ahead and haul her rape. Now, if I hadn't have been as controlled at the time as I was, I could have been charged with rape, or I could have been perhaps
What's your question? You want to know if you could be charged in those circumstances
no,
now?
what I want to do is say now, okay, if the laws are easier for women of this kind, turn around and charge a man and get results in court with rape, aren't you scaring the hell out of everyone?
No, the laws.
At the end of the question, I want to listen to your answer on the TV.
Yeah, the laws don't make it easier to charge for a woman to charge a man with rape or sexual assault. The laws are intended to make it easier to prove those offenses which have actually happened. And the problem of the kind of situation you raise is one that obviously in the give and take of the adversary system, which is designed hopefully to bring forward a truthful result in the end, would not face a great deal of difficulty. I mean, you know, the question of charging somebody has nothing to do with these new offenses.
Go ahead, please.
Yes, good morning.
Morning.
I understand your 3 categories towards violence and that, but what I want to know is, does age have anything to do with that? Like, there's been a couple of rapes lately in Surrey where one is 4 and one was 7, and would they be put in the first category because there was no violence?
No, the one of the offenses which has remained unchanged, and that is the offense of having sexual intercourse with a female under the age of 14 who is not your wife. That is still an offense punishable by life imprisonment.
Okay,
Go ahead, please. Oh, sorry. Go ahead, please.
Hello?
Yes. Sorry, my mistake. That's you, ma'am.
Mr. Webster?
Yes. Yes,
Hello?
ma'am. Yes,
Yes.
that's you.
Yes, I was just wondering if this talk you're having this morning is about just abuse on older people or younger people.
Oh.
Well, these sections apply to everybody over the age of 14, essentially.
Go ahead, please.
Good morning, Mr. Wood and Mr. Webster.
Uh-huh.
I have a question about if the laws of these new rape laws have changed for the intention of rape. I had a man come into my apartment one time and strip right down, and I finally got out of the apartment, but he never got charged with anything, and I still think that was like intent to rape.
Well, that would be that might well be a sexual assault. Let me put it that way, because we don't know yet. It's not defined in these new sections, the term sexual assault, but common sense compels one to the conclusion that it isn't going to be an awful lot different than the old offense of indecent assault, which the kind of circumstance you suggest might well give rise to a conviction for that offense.
Yeah, yet the courts did nothing. Like they just said that it was sort of breaking and entering, yet he did, strip down and stuff.
Well, if there's no form of assault, of course, then you were missing an essential ingredient of the offense.
Let me ask a question, though, and I don't want to confuse myself. That's dangerous to confuse yourself with too much knowledge. Indecent assault, that's still a separate offense.
No, that's disappeared
That's
as
gone.
well. That's gone. Indecent assault on a female is gone. Indecent assault by a male on a male is gone as an offense. Those were offenses that carried, the latter carried a punishment of 10 and the former carried a punishment of 5.
But there are other specific sexual offenses in the criminal code, are there?
Well, there are a myriad of other offenses that remain. The so-called perversion offenses, gross indecency, buggery, bestiality, those offenses remain. The so-called seduction offenses remain unchanged, basically, except corroboration has been removed from them as well.
What's a seduction offense?
Well, intercourse with a female between the ages of 14 and 16.
On a promise to marry?
Promise to marry is one, an employee is another. There are a variety of these offenses that are in the criminal code.
They're still extant in the code?
They remain.
Go ahead, please.
Hello. You were talking earlier about an honest but mistaken belief of consent. Does this have to be a reasonable belief?
Yes, it has to be a reasonably held belief.
So a rapist could be convicted even though he honestly believed consent, but it was an unreasonable belief.
Well, the test which the court has established is that there must be an honest belief and there must be a belief that a reasonable person could entertain. Now, that's really a twofold test. There's an objective and a subjective test. The objective test is whether or not a reasonable person in the circumstances could be mistaken, and secondly, whether or not the person in question was genuinely mistaken.
So therefore there must be a full trial of every nuance of the sexual circumstances in that particular case.
Yes.
As between the two parties.
Yes.
Without corroboration.
Yes.
Corroboration is no longer necessary.
Corroboration is not required.
Go ahead from Prince George.
Good morning. I would like to know how these new rape laws affect married men and women. Like, is it easier for to charge a husband with rape?
We've covered that briefly, but Mr. Wood will give you it again.
A spouse can be charged with a sexual assault by his or her spouse.
Fair enough. Go ahead from Balfour, BC.
Yes, gentlemen. About the legal aid cutbacks Mr. Wood was speaking of, I think what will probably happen is the staff lawyers that are left will undoubtedly take on the bigger cases that come up in that 3-month period and adjourn the smaller summary conviction type offense cases and back up the courts even more, and also result in some people maybe waiting in jail for 3 months where they shouldn't.
Well, that's true, and the bigger you talk about the bigger offenses, that means that there are going to be a lot of so-called little offenses that are going to be left where the accused is going to have to fend for himself. There is only so much time and manpower.
You were saying how they weren't going to be having ad hoc lawyers is the impression I got from what you're saying.
That's right,
and
for those 3 months.
Also, in addition to that, be cutting back the staff lawyers available.
Yes.
Good.
Maybe somewhere in the 20s or 30s throughout the province, from what I gathered from what you're saying, and I think there's going to be a lot more than 20 or 30 big crimes go on where people are going to need legal aid in 3 months.
Yes.
Well, I'm grateful to you this morning, Josiah Wood, for your expertise on the rape laws and your concern, because I've been a little bit cynical about legal aid. Maybe I should change my mind.
I hope you do.
My thanks to Josiah Wood. Next, we're going to talk to Dr. Michael Livingston and Ezekiel, if you can believe it, after the break.
Avoid loads that are too heavy. Move your feet when you turn. Use correct posture, standing or sitting. And lift with your legs, not your back.
Michael Livingston, MD, is an acknowledged expert on backs, and it's quite obvious why I wrote the book, because every second person has a bad back, and the medical profession can't seem to help them. Is that correct?
That's right. We have a pretty bad reputation for backs, I think,
no,
Jack.
I'm not knocking
No, generally.
you.
No, I don't mind.
It's
I mean, it's
very
quite true.
difficult thing, isn't it?
It's a difficult problem, and not only every other person, but probably 4 out of 5 people sooner or later will have trouble with their backs.
Now, is this the head, or is this the head? That look. What is this?
Some people's head. It's got holes in it, but actually it's the pelvis. It's the bottom, and this is the spine, and these are the nerves coming out through the vertebrae, and this is the base of your skull.
This is.
Here's your neck. Would be here.
I'm sitting down.
You're sitting down right there.
That's rather repulsive, Ezekiel, isn't it?
Ezekiel is a very fine person. And
all right, where's my bad back? Doctor, I have a terrible pain in my back, and they've taken x-rays, and I've been to chiropractors, and I've seen osteopaths, and all they say is you'll have it for the rest of your life.
Well, probably I should think, looking at you, Jack, is probably because you're basically out of shape, and have been out of shape for years. You have a job which is a fair amount of sitting. Your abdominal muscles will be weak, and your back gets strained. A lot of it will be from straight
well, I get
bad
news for
position.
you. I don't have a bad back, so boo.
But you've got a bad neck.
That's only because I have a self-inflicted whiplash from hitting my head repeatedly on a beam over on Salt Spring Island. But I'm going out of an accident today so that I can claim whiplash and get $50,000.
Well, I guess...
hope nobody's listening.
Yeah, no. Yes, I don't know whether you'd be worth $50,000, but at least you could try it.
Okay, most common injury.
Most common injury. I think really this is a mixture. Most pains are a mixture. We talked about relatively weak muscles, most people in society being out of shape, a lot due to the sort of work we do, the sort of lives we lead. I mean, you're like me, most of us are in this condition. The positions of which we are, the initial injury or illness that started it off at first, and then stress and tension, which I don't know if the camera can pick that up, but the sort of cat, dog, probably not. But it's a mixture, and in the book, right at the beginning, we get into the action right away, showing the causes of pain, which are on page 9, for example, in Back Aid.
Are you telling me that a nervous condition or tension can make my back bad?
It'll certainly be an aggravating factor.
Normally, it's degeneration or injury.
Yes, very often it's all three.
All right, now if a doctor advised me to have an operation on my back to refuse my spine or refuse a disc, I would take a second opinion, a third opinion, and refuse the operation. Am I correct?
I think you're pretty correct. Only about 2% of people with backache ever will need surgery.
2% ever will have surgery that
on
helps.
their back. No, I think if the operation is properly judged, in some people they definitely need the operation, but it's unusual. And I find also with operations that have been advised, very often the patient hasn't originally had a proper series of exercises or instruction in position to rehabilitate and build up their own muscle structure. This often has not been done. They may not have had adequate rest initially. They may have had some very silly treatment which doesn't help, and they then may end up in surgery. When they've had surgery, at least half the patients are not properly rehabilitated after surgery. Now,
can you carry on?
But if it's done properly, it's a perfectly reasonable operation in the people who really need it, the 2%.
2% out of every 100 cases seen, I suppose. Now, I know that occasionally when one has a muscle problem, or a back problem especially, the doctor might well put me on a muscle relaxant. Is that an instant and permanent cure in some cases?
Not very often. Most of the back problems have, say, an element, a mechanical element causing them. So if you drug somebody and they have a mechanical element, you're not really dealing with the problem. You're just giving drugs, when you should do something about their mechanics. Now, I can give you an illustration of this.
Yes, please.
Because I saw somebody yesterday, they came in, and this is what they had. This is a girl who was using a machine which she was sitting at all day like this and doing this kind of thing, stretching forward, bent a bit forward, so her neck is permanently up, extended a little bit backwards. She's bent forward. These muscles ache all day. If you try, put your hand over your head. Try it just for 2 minutes and see how it feels. Just keep it there for 2 minutes. And, well, maybe 2.5. And I figure that at the end of 2.5, it's going to bug you a bit. Now, this person, you're keeping your hand like that over your head for 2.5 minutes. You just try it. I bet you say, of course, it doesn't hurt at all. But
I normally sit like this at home.
That's it.
It prevents me from having a glass in my hand.
Ah, I see. Yes. Well, that's that's very sensible.
But
usually, about 2.5 minutes, the muscles up here begin to tire, and you get some aching, which in about another minute will come to you, some aching up here. Now, it may not occur with you because you're strong, vigorous, and good-looking, but most people get this.
Am I correct that the only
Can I just finish off about this patient?
Yes, yes.
Now, here she is bent forward. The muscles go into spasm, and she aches at the end of the day. So, she has already been to. She starts off, she went to a physiotherapist for some 20 visits and had her neck pulled. Why her neck was pulled for trouble in her upper back, I don't know. And she had funny instruments and things put on her back, so she had 20 visits there. Then she went off to a chiropractor who just touches you. He doesn't do anything else. Neither of these people explained position or exercises to her. He went on for 30 visits. Then she went to a physiotherapist who was the only rational person she went to, who in 6 visits explained to her the things that she should do, etc., gave her rational exercises. And then, after that, she went off to another chiropractor who's whacking her neck around. Now, that isn't to say all chiropractors are bad, but she's been to 3 out of 4 people, and only one of them has really done a good job on her, and she was the person who did the least, i.e. the least treatment was the best.
Okay. Is swimming the only safe sport for people with back injuries?
I think swimming and walking are the 2 safest and best sports.
This is silly.
Oh, it can be silly. You can put it down. I know you're just making a point. Whether it's aching or not, you're going to keep it up there.
Dr. Michael Livingston, your guide to the care of the back, will now get down on the floor and use his own skeleton, which is probably a little bit shachly, because he's so tall and skinny, and give you some demonstrations of how to relieve your back pain after the break. How much is your book?
Oh, my book? This book? Yeah. It's $14.95, cheap at the price.
It's only $12.95 of autographed.
Oh, yeah, it cuts it down if you autograph it. Yeah.
Go ahead to Dr. Livingston. That's you, ma'am.
Good morning, Dr. Livingston.
Good morning.
I'm sorry I tuned into your program rather late this morning, but I am very interested in what you've got to say, because I have now been flat on my back for 2 weeks with what my orthopedic surgeon diagnosed as sciatica.
Could be.
I had a disc removed 2 years ago, a ruptured disc, but when he x-rayed at the hospital 2 weeks ago, he said that the x-rays showed that the discs appear to be all right. However, I don't seem to be making a great deal of progress.
Well, it's not quite the kind of call we want unless you want to re-diagnose the orthopedic surgeons.
Yeah. There is a slight difficulty with, I feel very sympathetic towards you. There is a slight difficulty in trying to diagnose something over a telephone, as you must realize.
Yes.
So to give an opinion of that sort, particularly with somebody who's had previous surgery, is practically impossible.
Unfortunately, I missed, though, where I could reach you.
Well, I tell you what, in this kind of problem, you might actually find that this book answers quite a few of your questions, particularly in view of your position of once the acute pain settles down, you can do a sort of a limited pelvic tilt, and there are 1 or 2 other things you can do which actually will help.
Thank you. Now, next question. Sciatica. Is that a common back pain, and what causes sciatica?
Well, sciatica basically means a pain in your leg, and it's usually associated or considered to be associated with a problem in the lower back, whereby the nerve is irritated and the pain goes down the leg.
Can it be corrected, or you must wait for it to go away?
Well, again, it depends on the cause of the sciatica. A lot of sciatica is just a muscle, a kind of sprain you talked about, a so-called a lumbar sacral sprain or a low back sprain. One of the difficulties of all this is us doctors are very guilty of using dissimilar words to describe the same thing, which makes it very difficult for patients.
Go ahead, please.
Hello?
Yes, sir.
Doctor and Mr. Webster, good morning.
Yes.
I'd like to ask 3 questions and then hang up and listen to you.
Go ahead.
I had two fusions on my back in the last 2 years, and apparently they did not take, and the specialist thinks that another one would be required, but I'm very, very scared because this time they have to open me by the abdomen and work by the front to the back. Now, will pills in the long term hurt me? And also I have arthritis in my back. Now, what would you suggest another operation? I'll hang up and listen, and thank you very kindly.
The first, I simply cannot properly answer that question. That is, do you need another operation? Again, it requires very careful assessment. See, both the last two questioners actually have brought a slightly unusual and uncommon problem, because 95% of people, it's more simple than that. The last one is particularly difficult. To say, are pills likely to be a problem? I think very likely you get too many pills in this situation, and they really won't help too much.
What is arthritis in the back?
Arthritis in the back, unfortunately, very often is not really arthritis in the back. It's often described on an X-ray by simply calcium, which eventually is put down in our ligaments and shows up in the spine on the X-ray, and this may occur without any symptoms of any kind at all. Most of us have arthritis, so-called, in the back as we get older. It's inevitable. Calcium is laid down. Usually it does not cause pain. It's the tissue around the ligaments that are causing the pain.
Tricky one. Go ahead, please.
Hello?
That's you, ma'am.
Yes, I fell down several months ago, and I compressed the 9th vertebrae, and I've had about 30 therapy sessions, and I'm taking muscle relaxants, and nothing seems to help. If I do any work at all, my back gets aggravated, and I just have to quit. Is there anything that could be done, or will this continue indefinitely?
At 9 months, the bone will be healed. It would depend a little bit on the amount of compression, of the angle of the compression in the vertebra. That is, the vertebra gets squeezed, and it sometimes is angled a bit. If it really isn't crushed very much, there is no reason why you shouldn't be put on a sensible, careful campaign of graduated exercises, and these really should help you.
Go ahead, please. And of course, lose weight, be fit,
well,
do your swimming.
Sometimes, yes. It's sort of got to be done in a gradual, steady way. You can't suddenly do it all, but you know. But often people are not really doing sane exercises. I see a whole bunch of people, and the exercises they're doing are ridiculous.
You wouldn't go out jogging, for instance?
No, you wouldn't. Not at that stage.
I think it's silly anyway. Breaks down your kneecaps. Go ahead, please.
Depends how you do it.
Yes, good morning.
Yes.
I'd like to ask the doctor what exactly a herniated disc is, and also what he thinks of anti-gravitational devices that are currently on the market.
A herniated disc is where the material in the disc is squeezed out after the disc is torn or ruptured, and eventually this may or may not press on a nerve, giving pain. The anti-gravity devices are mostly perfectly reasonable. Some, you see, farmers will hang from their hands in the barn and do that for, say, 45 seconds and get relief that way. Some people lie upside down and have their heels fixed up to the ceiling or on a form of apparatus, which is perfectly reasonable also, both basically providing traction on your spine, and both can be quite helpful.
Can you do aerobics on your back?
What do you call aerobics?
All these... like the Chinese in Peking. Tai Chi.
Well, I deliberately in the book show 4 or 5 basic exercises which are very carefully explained. You see, most back books show you 30 exercises. They don't explain them well. There are clear diagrams in here and the odd cartoon, which makes it, I know backache isn't funny, but it makes it easier to read. It's clearly put together for people. The illustrations were done by a friend of mine, Sam Louie, who was a pharmacist over in the North Shore. And
yeah, it's a good common sense book. You obviously can't diagnose everybody's complaint on the telephony. Go ahead, please. I've done you. Go ahead, please. Where are you?
Hi.
Hi.
Hi, Jack?
Yes, yes.
Dr. Livingston?
Yes, yes.
Hello.
I can hardly hear you.
Well, we can hear you. Speak up.
I can shout if you like.
I had a treatment done by Dr. Livingston where 4 other therapists in the compensation board that turned me down, and he cured me.
Oh, you got a reference.
1 in 1,000. That's very good.
I had a pinched nerve in the back of my neck, and I was almost a year on it. And I had to work, and I couldn't lift my arm, and I would be sitting up in the Chesterfield sleeping instead of in bed.
Goodbye,
It's
goodbye.
nice of you to say that.
Give me a last word of advice from Ezekiel.
Can I say one more thing from Ezekiel? Now, in the past, now people say there are all kinds of treatments and backaches. Of course there are. In the old days, people actually used, in Central Europe, a trained bear was used in mass to walk on people's backs. And also, they sometimes use trained virgins to do this. Now, as you're in the media,
what were
Jack,
the virgins trained in?
well, Jack, I thought you'd be experienced enough to know whether there were these kind of people available. But if they aren't,
around here.
if they aren't, then one has to go with the medical profession, the chiropractors, and the physiotherapists.
Do you recommend chiropractors?
I recommend good chiropractors who do also show people proper position, proper exercises, don't bring people back 30 times, don't over X-ray, because the long, wide-spaced film of the X-ray of the chiropractor, the ones who do that type over-radiate people, and they shouldn't really be doing it.
But it's a good common sense book. It's $14.95. It's by Dr. Michael M. Livingston, MD of Richmond, and it's called Your Guide to the Care of the Backache. And Ezekiel did not write the book. Michael Livingston wrote the book.
And some Duthys and a few Woodwards.
They want it, they'll find it.
They'll find it.
After the break.
Okay.
I was taken away from home when I was 9 years old, and I was put away where I cannot see my people. I suffered during those years when I was away from my people. And I know today how the children feel. I know today how the little ones, they have lost their identity.
I think it's fair to say that the whole of Canada is on a guilt trip just now as far as certain Aboriginal rights are concerned. But more specifically, there's always been a problem in British Columbia of what happens to the native children who are taken away from their families and put into the care of non-native people. Patrick Johnston has written a book on it, Native Children and the Child Welfare System. Of the 8,000 children in care of human resources outside of Vancouver, how many of them are in fact native, non-status and Métis children?
I think something like 37% of all those kids are non-status, status, or Métis.
Is this merely a bad habit, or was it because it was ruled by MHR and others before them that native families could not properly look after, in their appalling housing conditions, these children with problems?
Well, I think there are a number of factors. In some instances, those kids had to be taken into care because their parents couldn't look after them, quite obviously. But there are a couple of other factors that come into play to explain why the number is so high. One of them has to do with a jurisdictional standoff between not only the BC government, but other provincial governments and the federal government over which level had responsibility for providing child welfare services on reserve.
I've never been able to find out who is really responsible for child welfare for native children in British Columbia.
That's right, because both levels of government point the finger at the other guy and say it's their responsibility, and that issue has never gone to court to be contested. And so in the meantime, what happens is that the full range of child welfare services that are provided to any families in BC are not available to families on reserves. And some of those services would probably help the family and prevent the child from being taken off in the first place.
So we've got all this perpetual confusion.
It's constant, and it's been the case for about 20, 25 years now.
Longer than that. When I came to BC in the 40s, I remember the religious schools and various incredible institutions. There were incredible institutions, and we don't want to name any, where the children, to say the least, were treated in a very off-handed, arrogant manner by non-Indians.
Yeah, that's right.
Do these conditions still exist?
Well, no, not in the residential schools as much, but there are many people who look at the demise of the residential schools for placing Indian kids and look at the child welfare system and say the child welfare system now is playing the role that the old residential school system
Except they don't put them in residential schools, they put them with non-native families.
That's right, that's right. The majority of native kids, not only in BC, but this is true right across the country, are placed with non-native foster homes, adoption homes. In fact, the national statistics in 1981 were something like 77% of all status children were placed with non-status or non-Indian families.
Was that ruled to be illegal at one time?
No, I don't think it's ever been illegal. There are many Indian people who are saying that it's unfair because the culture for those children is lost, and that poses all sorts of other problems in addition to just the removal of the child from his own family. But I don't think it's illegal.
There have been many successful foster homes for Indian children in white homes.
Absolutely.
Non-Indian homes.
That's right. There's no question that some of those placements have been successful, but there's also a lot of placements where many non-Indian foster families and adoptive families have not had help in understanding that the culture, the role of culture may be important for their child, and to help that child explore and find out the culture that he comes from. They're in a dilemma as well.
I suppose so, if one can accept and believe everything about culture. Normally when immigrants come to a country, as in this country, they lose their culture.
Yeah.
You can look at a number of specific races within 3 generations.
Yeah.
And that ain't all bad, you know.
No, but Indian
Makes
people...
for a homogenous society.
Well, you know, Canada is one of the differences between Canada and the States, of course, is that we like to see ourselves as a mosaic of different cultures that
Not
can
you,
exist
you mean
as
the
opposed
liberal
to the melting.
government. The liberal government,
many other people too
like
see that as a
myself,
difference.
you know, I know I'm an unrecalcitrant on this particular issue. As far as the non-natives are concerned, I want to see this country not a mosaic.
Right.
I want to see a homogenous Canadian.
Many Indian people, though, would reject
I don't want
that.
a subsidy to play my bleeding bagpipes.
Many Indian people, though, would reject that.
Oh, I realize that. This is written, of course, from their point of view.
Well, I've tried to be fair, but I think it's also fair to say that it probably supports many of the arguments that Native people have been making.
Let me ask you a specific question. If I'm an Indian child and I'm in federal care, I can be in either federal care or provincial care.
In BC, you're only in the care of the provincial government.
What about on reserves?
Even on reserves, they have an extended an agreement with the federal government where they will remove the child from the reserve. But the child stays in the care of MHR, not Indian Affairs.
But if I'm an Indian child not in care,
right,
I can either be in federal or provincial care.
Well, if you're living on reserve, then you're the responsibility of the federal government.
If I'm an Indian child under the responsibility of the federal government, do I get things like dental treatment that I get from MHR?
There are certain benefits that any status Indian gets as a result of his registration or her registration. Education. I don't know the full range of medical services that are provided, but that's if the child's on reserve.
Did this question of children being taken away from their own culture and put in non-Indian foster homes, did that come, I suppose, from the prejudice of social workers?
Well, to some extent, I think that's the case. I think that there are some Indian children who have been brought into care who probably shouldn't have been. And the reason they were brought into care is because some social workers didn't have an understanding or appreciation of some of the cultural differences and were using middle-class white standards to judge Indian families inappropriately.
Yeah, I can believe that. I can see that. And it's almost comprehensible in some ways when you think of some of the appalling conditions that have existed in the past 25 years. No running water, no fresh water, no decent toilets. Now, but there are some bands in BC which are successfully in control of child welfare.
That's right. The Spalmachine Band, I think, in the interior is one example that has had its own full responsibility for child welfare for something like 2 years now. From all I understand, it seems to be running okay. And that's certainly the direction that a lot of other bands want to go in as well.
What recommendations do you make in your book, and we seriously want to hear them, for the equitable treatment, because I don't think they've had a fair deal either culturally or socially.
Right.
in my time. What recommendations, what must we do to make it fair and decent for children who must be taken into care from native background?
Jack, the book is full of a number of very detailed, specific suggestions, which I won't go into now, but I have suggested as a kind of prerequisite for positive change. We have to increase the involvement of Native people in the child welfare system, in the planning, the development, and the delivery of services. Now, that can happen in a variety of different ways. In some instances, there are already some good examples of how that's happening in BC and in rest of the other parts of the country. That's one of the solutions. The other solution, though, is that the whole area of authority and jurisdiction has to be resolved. And I think that it's only going to be resolved when it's put on the table at some of the upcoming meetings as a result of the constitutional meetings last week to try and define the terms Aboriginal rights.
Well, of course, if they get some form of sovereignty, which is unlikely, they would then be in. Do you recommend that the Indian bands should be given, or Indian Aboriginal people should be given sovereignty?
Well, sovereignty is a very difficult term to define. I don't think that we can give Indian people or any people exclusive sovereignty in this country. I think that there are shades of sovereignty, or there are different levels of sovereignty that are perhaps feasible and will work in the Canadian political system.
Have we now stopped, as a matter of course, putting Native children into non-Native homes?
No, I would say the majority of Native kids are still being placed in non-Native homes. And
should we?
I think that we have to start developing Native resources. That's possible, but it's going to take a lot more willpower on the part of MHR in particular.
For those interested, and you should be, in the Native children problem, this is a book by Patrick Johnston, Native Children and the Child Welfare System. Thank you, Patrick.
Thank you.
Best of luck.
Thank you.
Native children need it. After the break. Another Tory leadership candidate is going to whistle through the studio and wave tomorrow morning, a fellow by the name of Peter Blakey, I think it is. And we're going to have Dr. Jeannie Stellman, who's one of the top experts on occupational health hazards such as VDTs or television cameras. Tomorrow at 9 a.m. precisely. Canada's new rape laws on Webster and Check at midnight.